It's estimated that there are nearly 1.6 million violent crimes in the United States each year. It doesn't matter what part of the country you're in, any assault charge can carry major penalties that can change your life forever. Here in North Dakota, the courts are particularly tough on these types of violent crimes. That's why it's vital to familiarize yourself with the laws surrounding criminal charges for assault in the state if you've been charged. In this video, we'll walk you through assault charge types and the various penalties they carry. We'll also provide you with resources that can help you avoid conviction or minimize your penalties. Simple assault versus assault. According to Chapter 12.1-17 of the North Dakota Century Code, simple assault is defined as trying to cause injury to another individual. This also includes negligently causing an injury with a weapon that is likely to cause injury or death. In North Dakota, this type of charge is a Class B misdemeanor. That means you may face 30 days of incarceration as well as a fine of $1,500. The exception is if the person is a peace officer, hospital worker, firefighter, court proceeding official, or emergency medical worker. In these cases, simple assault is raised to a Class C felony. Domestic assault shares a lot of similarities with simple assault. The difference is that domestic violence occurs between a family or household member. In the law, regular assault has the same definition as simple assault. However, a conviction with regular assault is a Class A misdemeanor compared to a Class B. A Class A misdemeanor raises the incarceration period to 1 year and increases the fine to $3,000. So what's the difference? The answer lies in the amount of injuries you cause. If you cause multiple injuries, or they're serious injuries, simple assault can be upgraded to regular assault. Aggravated assault. Like simple and regular assault, an aggravated assault occurs when someone causes bodily injury to another individual. The difference is that instead of negligently causing the injury with a weapon, the individual in an aggravated assault does it knowingly. Discharging a firearm or throwing a potentially destructive object at a person is also classified as aggravated assault. Aggravated assault carries some very serious penalties with it since it's classified as a Class C felony. If convicted, you could face up to 5 years of incarceration as well as a possible fine of $10,000. Also, if the aggravated assault was committed against a child under 12 or a peace officer on duty, it's upgraded to a Class B felony. Facing an assault charge in North Dakota can be stressful, especially once you learn about the penalties. The good news is that there are things you can do to minimize your chances of getting a penalty. Let's discuss what to do when you're facing these criminal charges. Be careful what you say. Often, immediately following an assault, you're in an aggravated state. If you've been arrested, it's easy to say something that could potentially incriminate you. As soon as police arrive on the scene, stop talking. You can answer any simple questions, but remember that you have Miranda rights for a reason. As such, your lawyer should be present before you answer any questions. Hire a criminal defense lawyer. There are some cases in court where you may not need the legal help of a lawyer. An assault charge in North Dakota is not one of these situations. If you attempt to represent yourself, it's almost guaranteed that you'll face the maximum penalties. When you're facing assault charges, you should contact a criminal defense attorney for protection as soon as you are able. Make sure that the lawyer you're contacting specializes in this type of criminal defense. Then, describe the situation to them and ask them for recommendations. You want an attorney that doesn't leap to judgment. A good professional will only care about your rights. You want to make sure that you can trust your defense lawyer. Why? Because they'll be representing you from the start of your trial right through to sentencing. And if you're convicted, your lawyer will be responsible for handling your appeal. Await the arraignment process. The arraignment process is when a judge will decide if there's enough evidence to take your assault case to trial. If they decide there's enough evidence, they'll tell you the charge and your court date. They'll also decide whether or not to release you. If bail is required, the bail will be set at this time. Your lawyer must be present at the arraignment process to give the appropriate responses. Prepare for trial. During this time, your lawyer will prepare the best strategy for proving your innocence or minimizing your sentence. This starts with finding potential eyewitnesses or character references for you. If there's not enough evidence to convict you, there's a good chance your case could get dismissed. If there is evidence that proves you're guilty, your lawyer will work to get it out of the courts. If they can't, they might recommend a plea of guilty to get a better deal. It's important to be as forthcoming with your lawyer as you can. That way, they can prepare the best defense for you. The professionals at Heartland Law Office know that a criminal charge like assault can put your entire life on hold. That's why they'll do everything in their power to protect your rights. If you're ready for judgment-free representation, contact Heartland Law Office today to request a free case consultation.